Thomas, are you there? Here we are.
I am.
Let me ask you about this because we were just listening to Mark Richards talk about the relief that this case is over. Give us a sense. I mean, you've been in his shoes before. This was a high-profile case, a lot of pressure on him. In essence, taking a victory lap today. Is that what you heard?
You know, didn't see or hear him as much as a victory lap as someone who was very humble about the fact that the process took place, that justice is the process and not the result, which is something that, you know, I think we saw from the defense counsel today. He wasn't gloating. He wasn't in any way taking advantage or cheering for himself or cheering for his client. He was just happy that the process ended up coming through and doing the right thing during the course of the trial. A lot of the stuff that he ended up talking about with regard to how long this took is something that I think all of us that have tried juries understand, that, you know, you go through and you're at day 2 or day 3 in the jury being out in a case that is high profile, and you're wondering what the heck could they be thinking about. You know, they heard the same evidence I did, and it was just really resounding to hear him talking about things that we all go through. I think truly, though, the jury did not want to go into Thanksgiving week deliberating, so they came to a verdict, and they ended up coming to that verdict based upon that kind of outside, intangible pressure.
A lot of people talking about Kyle Rittenhouse taking the stand in this case, and I thought it was interesting that Richards replied to that question saying they had no choice. Were you surprised by that response? And also the insight that he gave us into just how scientific it becomes, that they have these, you know, practice, I guess, juries that then give them an idea of whether or not Kyle Rittenhouse would have done well on the stand.
You know, to address the first question with regard to a defendant being on the stand when you have a self-defense claim, it's almost, there is absolutely no other choice. You have to put that person on the stand to explain to the jury what happened, because you're trying to get them to see the case through the eyes of the defendant. That's the first thing. And the second thing is they have to connect with the person, and they have to look at the person as a human being instead of the monster that the prosecution is trying to paint them as. So looking into their eyes and then hearing their voice and hearing them describe what happened. Are they robotic or do they have compassion? And those are things that jurors look for, and connectability is a huge factor in whether or not your client is convicted or is found not guilty. So putting the defendant on the stand in a self-defense claim is just absolutely paramount. Number two, you know, with regard to, you know, how this case came about and the scientific methods of a mock jury. Mock juries are helpful, but we also have to remember that mock juries, while they may give us some common denominators, juries are unique beings, and they come together as a collective, and they have their own personalities and they have their own thoughts. And if anybody doesn't believe this, then, you know, just kind of contrast sitting with your family talking about things, or sitting with your work friends versus sitting with your friends at home or that are in your neighborhood. They're different feelings, different vibes. There's different leaders, there's different followers. And that's one of the things that we have to be concerned with. As many mock juries as we do, we still have to deal with the real thing when we get into court. It gives us a nice guidance, but it doesn't end up being dispositive.
And I know this point has been discussed throughout this trial, but the issue of the narrative stories being told here, and also the facts of the case, Thomas, and really the jurors have to go one by one through each point that the prosecution and the defense made, and really that burden of proof that the prosecution had, that they had to prove this beyond a reasonable doubt. So even if something wasn't 100% certain, I mean, Thomas, it sounds like they had to vote no guilty if there was still that level of uncertainty, correct?
Yes, and you know, the defense attorney made a really, really good point in that the prosecution has to build that trust right off the bat. And when the prosecution makes one statement in their opening statements and the evidence shows something different well into the case, it erodes that trust. And once that trust is eroded, and you have the death by 1,000 cuts, which you did in large part here during the course of this case, they begin to not trust the prosecutor. And when they don't trust the prosecutor, they don't trust the message that the prosecutor is giving. And because of that, you end up with a stronger case as a defense attorney and a stronger case with the defendant. When you're weighing on the scales of justice, who should I believe? The prosecution has ended up telling me one thing happened, but the video shows me something completely different.
Can we talk? I know previously our colleague Patrick Fazio was talking with you about next steps and possible federal charges or possible civil cases being brought against Kyle Rittenhouse. Can you enlighten us as to what could happen next in this situation?
In the majority of these cases that we're seeing, let's just take the Minnesota case that just happened. You had police officers that ended up, essentially killing an unarmed individual. And the actions, the majority of the actions are 1983 actions where, you're acting under color of law. In other words, you're acting as a government employee or in a government role. And because of that, it gives the court jurisdiction over you under Section 1983 to then subsequently file those charges that you denied another person their rights under the Constitution under color of law. There's been references made to the fact that he crossed state lines, but if you recall, the Lake County, Illinois prosecutor, Mr. Nurheim, ended up taking a look at this case and determined through his investigation that the weapon was not taken from Illinois into Wisconsin, and it was both purchased and stored in Wisconsin and never left the state of Wisconsin. Because of that, it kind of takes the jurisdictional issues away from the federal government. Could they claim that he started the conspiracy, so to speak, in the state of Illinois and then came over to the state of Wisconsin? They could, but murder is almost exclusively a state crime as opposed to a federal crime.
Thomas, I'm going to ask you, we just heard from Mark Richards talk about the defense of this case, but Thomas Binger, who was the lead prosecutor, I imagine you've been in his shoes before. He's going over all of the arguments that were made in this trial, all the evidence, all the witness testimony. If you were to put yourself in his shoes right now, what went right and what went wrong in the prosecution's case?
This was a tough case from the onset for the prosecutor. They had to bring the charges, and I think we all understand why they had to bring the charges. But in the situation that they had, it became extremely difficult. Could you have put on the case differently? That's kind of what you end up thinking when you're a prosecutor and you lose a case, especially a case to a jury. You go back and you begin to look at the evidence. And in this case, should I have ended up focusing more on provocation and that he was there at the scene with a weapon and injected himself into something that he had no business, as opposed to claiming right off the bat that he chased somebody down and shot him in the back when that video evidence didn't show that. Additionally, I think I probably, as a prosecutor, would have gone back over and said and kind of thought about where did I go wrong in making sure that each and every piece of evidence was given to the defense, because that created some issues, and clarifying things and taking the time to end up, asking for things like sidebars with the judge to discuss evidentiary issues, as opposed to having it objected to in front of the jury and then have you castigated in front of the jury, also erodes your credibility. So those are things that I would be thinking of as a prosecutor. But in his defense, this was a really tough case for the prosecution. And it was a tough case because you did have people that were chasing him down. There were gunshots that were fired. There was him being beat with a skateboard, and there was a gun involved by the person who's a surviving individual who pointed the weapon at him, or at least in his general direction. So those are things that you're working against as a prosecutor, and I think that makes it a very, very difficult case for them.
I know I've sat on a jury, and following the trial, we did get a chance to talk with the prosecutors. Do you think in this case, the prosecution may want to talk to the jury and find out what worked, what didn't, and maybe where their case went wrong?
Allison, we've talked about your service on the jury before. I think it's a really, really important, and it gives you a great deal of insight into what occurred. In a case where they were going to retry the defendant, in other words, if it was a hung jury, I think it would be really, really important for them to sit down and talk about with those jurors what went right, what went wrong, and where did we, get to a point where jurors got hung up, and help me understand that. Because jurors sometimes will come from left field with things that you didn't anticipate. hate. And sometimes you get too close to the case, and I think that may have occurred with regard to this case, that sometimes prosecutors and defense attorneys get too close to their own case and they don't look at it objectively, which is the purpose of a mock jury. I think that if this were a hung jury, absolutely it would be important. Right now, since you can't appeal a not guilty, there really is no point in talking to the talking to the jurors, because what do they have to add other than you were wrong?
And then I did want to follow up, because I know last time I did ask you about the civil aspect of this. Do the families have any way to bring this case to court over their loved ones?
There are always going to be avenues to go forward with regard to civil ramifications against Mr. Rittenhouse. There's always going to be the ability for them to end up filing a wrongful death suit if that's what they wish to do. There are some issues with regard to each one of the people who were shot, as the defense attorney alluded to, and those are known to the people that are involved in this case. I found it really interesting, and this is one thing that I did want to touch on that I didn't get to talk about before, is that the additional charges, had they been able to work in an additional felony into this case, then they may have been able to proceed on what's known as felony murder. And if they were able and successful to end up proceeding on an additional charge, which they could have proved to the jury with regard to an additional felony that is not a murder case or not a murder charge, then you cannot claim self-defense on what's called felony murder. If you're in the commission of a felony and someone else dies as a result of the commission of that felony, then you are guilty of felony murder. And that would have undercut the whole self-defense claim, which in retrospect, looking at this, I think I probably would have thought about as a prosecutor prior to charging the document.
All right, Thomas Glasgow giving us some excellent analysis in the aftermath of this trial. Thomas, thank you so much for joining us and for answering our questions.